So when we are talking about law, how the law is made, see, it is not one thing in which the law is made, or the law is not a single component. Rather, a law is a mixture of each and every component which is presented before you in this particular slide. Now, first things first, we are talking about an act. We are talking about Companies Act. See, what is our certification course? Our certification course is on company law. Now, we are not talking only about Companies Act 2013. We will be talking about each and everything. We will be talking about Companies Act also, Companies Rules also. So before starting with Companies Act and Companies Rules, we need to understand one thing. How the law is made. Firstly, for any kind of law, a bill is presented in the parliament. Various experts from the law field, they join hands in the parliament. Rather, they are the officials of the parliament, we can say. They draft a proper bill for it. That is a rough bill to it. That is known as the draft copy of the bill. Now that bill needs various amendments and amendments and amendments before it is presented to the parliament. See, in case of a central law which is applicable to the whole of country, the bill is presented in the Lok Sabha and then Rajya Sabha. And finally, the president is the authority to sign the bill and to enforce it as an act. In case of any state law, the state legislative assembly is held responsible and the governor is held responsible for the final implementation of law. Now, when we are talking about Companies Act, so before introduction of the Companies Act, the Companies Bill was drafted by various experts. Further, their bills were presently in the Lok Sabha and further than the Rajya Sabha, and then the president had signed the document under his signature, and the law became the act. It is not only for the Companies Act, it is for the entire set of acts which you read in India. So first things first, what is an act? Act is actually a parameter which defines what is law. What should be done, what should not be done is actually defined in the act. So type of law, that is a component of law which is actually presented in the Parliament of India or the state assemblies, state legislature. Now, what is Parliament? For our purpose, for the purpose of law, Parliament means it should be presented in the Lok Sabha, then Rajya Sabha, then the president needs to have the signature. Once the president has declared that it is a valid law, that is, he had signed the document, that bill becomes an act. Now, an act, what act actually prescribes what should be done, what should not be done. आपको क्या करना है और क्या नहीं करना है, right? That is defined under act. Now, various times it has been seen that act is a affair of parliament. Now, in the act itself, we delegate the responsibilities to a ministry. Say, for example, when we are talking about any law relating to the railways, the Ministry of Railway will be the in charge of the act, or it will be the supreme administrative body under the act to maintain the act, to maintain the legacy, and to run the act, to enforce the act in a proper manner. And the ministry, that is, what is a ministry? It is either a central government component or a state government component. That is the executive body. The executive body or executive body is the ministry which enforces the act by prescribing the rules to it. If we talk about Companies Act, the Companies Bill was presented in the Parliament. Then the Companies Bill was converted by the Parliament into the Companies Act. Now, the Companies Act defines that the Ministry of Corporate Affairs, MCA, that is a central government ministry, will be the whole and soul in charge to draft the rules. Now, how a ministry is actually defined, or how the ministry is actually presumed that in this particular act, this particular ministry will be the rule making authority. Now, what we are trying to say is how the ministry is empowered to make the rules is actually given in the act. There is a separate section, there is a separate provision which empowers a particular ministry of either the central government or the state government to define and draft the rules pursuant to the act. So the rules are actually being drafted in accordance with the act in the powers which are delegated in the act itself to a particular ministry. It can be the central government, it can be the state government. So what actually rules define? It actually defines the procedural aspect of how to comply with the law. The act defines what is law, what should be done, what should not be done. Now, what is defined in act. Now, how this particular work will be done, what will be the procedure to it, is defined by the ministry in terms of rules. Say, for example, when we are talking about Companies Act, Companies Act, there is a provision that the company must do so and so, or the company must conduct an annual general meeting. Say, for example, we are talking about any random section. Now, how the meeting will be conducted, how the notice will be issued, of how many days it will be issued, what will be the returns and annual reports which will be filed to the ministry. Now, what is defined in the law? To conduct an annual general meeting. That is the course of act. Now, how the meeting will be conducted, how many members will be present, how the procedure will take place to conduct a particular act which is defined under act. That particular procedures are defined by the rules which is actually drafted by the ministry. To make things more better, that to make things in more intricacy, I must tell you that the Companies Act 2013 is actually a rule based act. For each and every section, you can see as may be prescribed in rules, that is, the central government has been delegated with the substantial portion of the rule making authority under the Companies Act. I'm not talking about all the acts in India, that all the acts may or may not be rule based. That means majority of the provisions are contained in the act and some of the points are contained in the rules in other acts, in other laws. But in case of Companies Act, the act defines the bare minimum law, and all the procedures defined are actually defined in the company law under the company's rules. So this is a basic difference between act and rules. Now talking about the ordinance, that is a temporary law, urgent law, when the parliament is not in session or there is an emergency in the country. So the president, or in the case of a state, the governor has a special right to enforce a temporary law in India. That is known as ordinance. So act is a permanent nature law. Ordinance is normally a temporary nature law, which is directly been enforced by the president or the governor in case of state in the Indian legislature. So either the parliament or the state legislature, when they are not in the session, or even if they are in session, but the president believes or the state governor believes that there is an urgent requirement, we can't wait for a law to be enforced through a proper channel. That is Lok Sabha, Rajya Sabha, and then final consent. So the parliament, by skipping the parliament, the president or the governor can enforce a law. How these ordinances, how the power to make laws in terms of ordinance are being delegated to them, they are the constitutional powers which are assigned to the president or the governor to pass an ordinance. It has nothing to do with the company law or the Companies Act or company ordinance. That is the constitutional power. So the mother of all law is the constitution, and we are talking about ordinance as a constitutional powers which are given to the parliament, president and the governor. So but again, there is a limitation of the constitutional power, that the president or the governor cannot enforce an ordinance as a permanent nature law. That is a type of act. They are the temporary laws, normally up to 180 days from the date of its execution. Whenever parliament will be in the session, this particular bill or ordinance needs to be passed as an act. That is, it needs to be passed through the source of Lok Sabha and Rajya Sabha, and then again the final consent of president or the state legislative assembly or governor in case of state laws to convert the particular ordinance into an act. Otherwise, on the very next day, that is 181st day, that ordinance, if it is not converted into act, that law will be abolished automatically, or we can say that ordinance will cease to operate as a law of the land. So far so good. We can understand the differences between act, rules and ordinance. Is it everything okay? Is everything okay so far? So good.
Yes, sir. Yes, sir.
So we are talking about the next set of things, regulations. Now, what is regulation? Again, regulations are defined by the regulatory body. Now, who are the regulatory body in India? Very basics to start with. RBI. We are talking about RBI. We are talking about SEBI. We are talking about IRDA in case of insurance companies. Uh, these regulatory bodies, of course, when we are talking about SEBI, the entire capital market is dependent upon the regulations which are made by SEBI or RBI in case of banking industry. Now, how the RBI is born is it is actually born through RBI Act, as we can see in the law. How SEBI is born? The SEBI is born or established through SEBI Act 1992 or RBI Act 1934 or IRDA 1956 or whatsoever. So the regulatory body is actually a result of law, or we can say it is a result of an act. There must be a proper provision in the act to define a particular body, to make certain regulations on a particular topic or particular area, which may be or may not be feasible for the parliament to observe. Say, for example, if we are talking about Companies Act. Now, Companies Act have the proper sections to define an act. We have the proper ministry, that is Ministry of Corporate Affairs, to define each and every rule within the act. But when we will be talking about certain sections which directly or indirectly affects the capital market, when we're talking about chapter 3, chapter 4, and various sections, which defines how the securities will be issued, how the market will be there, operate, and what will be the law. So these are the proper specifics of law. That is, the act is touching a specific area, and there should be a proper regulator to regulate a proper area. Or we can say that is a specialization of that particular regulatory body. So in the act, we can define that for these particular sections or for these particular matters, the proper regulatory authority can make regulations. So when we are talking about Companies Act, the entire 470 sections comprehensive act defines what should be done, what should not be done by a corporate. How it will be done is a forte of ministry, that is Ministry of Corporate Affairs, that is by making the rules under the act. The rules can never surpass the act. The rules can never go against what is written in the act. We can clearly say the act is superior and the rules are subordinate to it. And in the act, to touch a particular framework, say for example in the Companies Act, there might be certain sections which touch the capital market. So for the capital market, for those particular sections, we can define that a particular regulatory body, that is SEBI in case of capital markets, may prescribe by regulations what should be done and what should not be done. So rules are always made by a ministry. Regulations are made by the separate body, that is a regulatory body. How the regulatory body is established? By an act. That is for sure. No regulatory body can operate without having its own statute. So the statute means its own act. Apart from the act, rules, regulations, and ordinances, we have the bylaws. Now, bylaws means what? When we are talking about regulations, say for example, we are talking about SEBI. How the SEBI will manage the capital market is what is regulations made by SEBI for the corporates, for the investor, for the rest of the world to regulate a particular system. But now the question arises, how SEBI will regulate itself? How SEBI, and now SEBI is itself a supreme body. SEBI Act has been made and SEBI has been given the major power or the supreme powers of a particular phenomena. But now the thing is how SEBI will operate within itself. Now, what will be the governing body of SEBI? How the SEBI will conduct its meeting? how RBI will function, who is going to tell RBI that how RBI should perform? Obviously, the government can interfere, but for the internal guidance, how RBI will operate, RBI will define its own bylaws. SEBI will define its own internal bylaws to govern themselves. So RBI will make the regulations for the banking industry. SEBI will make the regulations for the capital markets, but RBI and SEBI will define their internal affairs के लिए bylaws. Bylaws is something to govern yourself. So this is the difference between regulations and bylaws. Most importantly, lastly, but not most importantly, orders. Now, order is actually passed by an adjudicating authority. Normally, we can talk about it as court, it has tribunal. Now, why the orders are passed? Because there might be a disagreement, or we can say a dispute. There must be a compromise, there must be an arrangement, there must be a dispute. Because why the dispute arises, they are the matter of interpretations of law. See, when we are talking about law, there are two types of questions. I hope if you are from the legal background, you might have heard there are two types of questions: question of fact and question of law. But whenever two parties are sitting on the table and they are trying to define or they are trying to interpret the law, there might be so many cases where you define or interpret the law in your logic and I interpret the same lines in my logic, or what should be the correct form of interpretation that is missing between both the parties. When the consensus is not made, there is a dispute between the parties. In your opinion, you are correct. In my opinion, I am correct. That is a matter of dispute. Now, how the dispute will be resolved? By the adjudicating, that is the courts, the tribunals. Now, it is also part of law. It is also part of the system, which you call it as the judiciary. So the legislative body makes the law, that is the acts. The regulators also make the regulations. These are the part of legislature. Now, executives are the basically defines the rules. The executive bodies, that is Ministry of Corporate Affairs, will define the procedures. Of course, within the law, within the act. So the rules are actually framed by the ministries, the government, that is the executive body. And in case of dispute, the third pillar of the system is the judiciary, that we have written, that we have read the act, we have read the rules, still both the opinion differs, which creates a dispute, which creates a battle between two parties regarding the interpretation of law. And for the interpretation disputes, we have the courts and tribunals. So it is applicable only to a particular entity, not for the whole community. That means what we are trying to say, normally the dispute are between two or more parties, specific parties. What actually defines here, what is actually defined here is a law is also, or we can say a precedent is also part of law. Now, what is precedent is to apply your mind rationally in future. Say, for example, there was a dispute regarding a matter in which the law was not clear. Both the parties went to the court and the court passed an order. Now, what law says, or what even the prudence says, a logical framework says, that once a dispute has been decided in the court of law, so this, in the case of similar facts and figures, in the case of similar situations, you need to have a common sense that you should accept that particular order for all the subsequent similar nature disputes. So the orders can also can be taken as a law for the subsequent disputes. Now what we are talking about, the orders can be taken as precedent. So precedent means which presides something in the subsequent matters. So these are all the part of laws. Of course, we will be talking about the notifications and circulars as well. But majorly, these are the components of law. Is it clear so far, so good, Rishabh?
Yes, sir.
Simple. So to make things simple, we are again defining the bodies of law, which I had discussed in the previous slide. We have three pillars of law, that is the legislative, executive, and judicial. The legislative powers are actually defined to make laws. The parliament. Of course, I had written in some cases the government, but it is basically the parliament, the Lok Sabha, the Rajya Sabha, and the president in case of central law. And the Vidhan Sabha, the state legislative assembly, and the state governors are the prime authorities to make either the central law or the state laws. Why I had written the president and governor here? In case of ordinances. Why I have written regulatory bodies in case of regulations. Why I have written the adjudicating authorities? Because, see, once the dispute is settled, it is an order for a particular case, but it becomes the law for all the subsequent situations. The order itself becomes the thumb rule for all the subsequent laws. That is why the court order is actually a law. It is also a form of legislative body. Now what we are talking about, say for example, what is a legislature? Companies Act. Now who is the authority to define the procedures under the law? Is the executive or executory body. In the Companies Act, what we have? The Ministry of Corporate Affairs as the central authority to define the rules or to define the procedures, how the Companies Act will be implemented. So the major responsibility of implementation of an act rests with the implementation authority. We can call it as executive body, executory body. We can call it as the implementation authority also. And in case of dispute between the parties, who comes into the picture? The judiciary, the judicial system, that is the courts, the tribunals, the special courts, the appellate bodies. Appellate bodies are those bodies in which you can file an appeal if you are not satisfied with the order of a particular court. Simple. In this case, in the case of company law, we have the tribunal, which is a quasi-judicial body, which is not a full-fledged court, that is a district court or high court. It is a quasi-judicial body, tribunal, that is NCLT. And if you are aggrieved by the order of, if you are not satisfied with the order of NCLT, you can appeal or you can challenge the order of NCLT into the next appellate body, that is NCLAT. And of course, in the judicial system, if you are not happy with the order of NCLAT, you can approach the Supreme Court within 60 days as well. But to make things very legal, you all must know that in the Supreme Court, the disputes are only related to on the questions of law. The questions of facts are not entertained by the Supreme Court. The questions of facts are actually defined by at the last stage to the NCLT. Above it, the appeals to the courts, to the appeals to the Supreme Courts are only on the question of law. That